How do you prove to your judge that the soon-to-be ex is a manipulative liar? That is the question that we were asked. Well, my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues right here in the state of Michigan. And today we're going to continue our video series designed to educate and inform the public. So please subscribe to our channel. You know, it's very interesting, the question, how do you prove that your ex is a manipulative liar? Well, first of all, it's not about saying, oh, he's a liar, oh, you're a liar, back and forth, tit for tat. That is not how it works in the courtroom. The courtroom is based on not your word alone, although it does have some value, but it's based on evidence. So don't tell the judge things, show the judge things. You may, for example, want to present text message or emails or a social media post that supports your argument. Going in there with just a bald statement that he's a liar or she's a liar is not going to get you any traction. The court already knows, because we're in divorce court, that these parties hate each other, okay? They don't get along. You're not on his Christmas list. He's not on yours, okay? The court already knows that. So the fact that you're going to call him names, she's going to call you names, none of that means a whole lot without some substantiation. Once you can show the court what's truly going on, then of course the whole thing begins to make sense. You can expose lies. You can expose misrepresentation and fraud by documentary evidence. You should also use neutral third-party witnesses. You want to call your mother to the stand to testify that your soon-to-be ex-husband is a bad guy? Well, I don't know. I guess it has some limited value, but it might be better to call the next-door neighbor who has no skin in the game and who can witness that they saw this guy, come to your car in the middle of the night and break out the windows and write slurs about you on the side of the fence. That might be more helpful than having your brother or your father or your mother testify, someone who has a stake in the game. You want to bring third-party, totally neutral witnesses because that assists in the credibility of the presentation. You want to focus on provable facts. You may know a lot about your ex-wife, but you know what? If going through the evidence, if going through the emails and the text and the documents demonstrates that you can only prove certain things, don't waste your time bringing forth evidence that cannot be supported. It is better to finish off your case and then have your judge say, and judge, every single thing I told you I supported with a document or a witness. That has strength. That gives you traction. That has heft in the argument. To have a bunch of stuff that you made allegations and you can't prove them by the time trial's over just leaves a bad taste in the court's mouth, makes the court think that you're just grasping at straws. Don't be that way. Support what you say with evidence, and if you cannot support it, don't bring it in. If you have any questions about that, reach out and we'll be glad to help you out.
248-588-3333. 248-588-3333.